Hello everybody and welcome to Legal Studies Unit 3, Area of Study 1, the Criminal Justice System Part 4. The focus of today's video will be dot points 7 and 8, the purposes and appropriateness of plea negotiations and sentence indications in determining criminal cases, and the reasons for a Victorian court hierarchy in determining criminal cases, including specialisation and appeals. The purposes and appropriateness of plea negotiations and sentence indications. Plea negotiations are pre-trial discussions that take place between the prosecution and the accused aimed at resolving the case by agreeing on an outcome to the criminal charges laid. The prosecution offers an incentive to the accused to plead guilty. Plea negotiations will either reduce the charge to a less serious offence or remove some charges in return for a guilty plea for others. Victims should be consulted before plea negotiations. Their views should be considered. However, the prosecution can enter a plea negotiation without the approval of the victim. Public perceptions of plea negotiations are often that the prosecution is being weak on crime. The prosecution cannot disclose why they wish to negotiate with the accused, which contradicts the transparency that the judicial system is supposed to have. Some of the purposes of plea negotiations include to ensure a guilty plea to a charge that adequately reflects the crime that was committed, and to achieve a prompt resolution to a criminal case without the cost, time, stress and inconvenience of a criminal trial. The appropriateness will depend on whether the accused is ready and willing to plead guilty, whether the accused is willing to cooperate in the investigation, the strength of the prosecution's case, whether the witnesses are reluctant to give evidence, and the possible adverse effects of a full trial. Sentence indications are a statement made by a judge to an accused person about the sentence they could face if they plead guilty to an offence. Sentence indications can be given for both summary and indictable offences. For summary offences, sentence indications can be given at any time during proceedings. For indictable offences, the accused can apply for a sentence indication at any point in the proceeding if the prosecution agrees. A sentence indication can only be given once, and the court can refuse to give a sentence indication. Some purposes of sentence indications are to provide the accused with clarity around the likely sentence they will receive so they can make an early decision to plead guilty, and to preserve the time, costs, resources, stress and inconvenience of having a trial if the accused pleads guilty. The appropriateness depends on whether the accused has applied for a sentence indication, whether the prosecution approves of a sentence indication, the type of offence and the court hearing the charges, whether there is sufficient information for the judge or magistrate to make an indication, and the nature of the offence. The court hierarchy. Every court has its own jurisdiction, that is, its power to hear particular cases. The original jurisdiction is the power of a court to hear a case for the first time. The appellate jurisdiction is the power of a court to hear a case on appeal. Below, I have included the Victorian court hierarchy and the original jurisdiction and appellate jurisdiction for you to be able to familiarise yourself with. The reasons for a Victorian court hierarchy. We'll begin with appeals. Appeals provide parties who are not satisfied with the outcome of their case the opportunity to have it reviewed, if they have the grounds to do so, by a higher court. Appeals allow for any mistakes in the original outcome to be corrected. If there was no court hierarchy, a system of appeals could not operate, as there would be no higher courts to appeal to. Specialisation. Specialisation allows courts to have expertise in certain areas based on the cases they hear under their jurisdictions. For example, the Magistrates Court has expertise in summary offences that are dealt with relatively quickly. If there was no court hierarchy, there would be a backlog of cases, as the courts on the one level would be hearing different cases, some lengthy and some not so lengthy. Different courts have different expertise, meaning that judges are well versed in the law relating to that area and can make decisions that are consistent, predictable, and timely. That concludes today's video. I hope that your knowledge on dot points 7 and 8 from Unit 3 Area of Study 1 have been consolidated. If you do have any questions, feel free to email me or leave them in the comments below. Thank you.